Good morning, good afternoon from La Jolla, California. Welcome to our webinar and discussion of the new hydrocarbons law in Venezuela, amongst probably even broader areas of focus here at this webinar. My name is Jeremy Martin, Vice President for Energy at the Institute of the Americas. And for those of you who may not be familiar, the Institute of the Americas is a nonprofit public policy center located on the lovely campus of University of California, San Diego in La Jolla, sitting up on the mesa overlooking the amazing Pacific Ocean. And I hereby extend an invite to everyone listening and joining us to come out and visit us in La Jolla, preferably in October 13 through 15 when we celebrate our 35th annual La Jolla Energy Conference. We are delighted to be with Francisco Minaldi and the Baker Institute Center for Energy Studies on this webinar today. And I should mention that this is the first in a series of webinars that we, the Institute of the Americas and the Baker Institute under Francisco's leadership, will be organizing around the topics pertaining to the very fluid and evolving the situation in Venezuela. So please stay tuned for that over the coming months. Francisco will introduce formally the panel, but I just want to say we have a dynamite group of speakers lined up, top-notch legal minds, experts on the energy sector and Venezuela, Elizabeth El Houry, Jose Vicente Zapata, Fulvio Altaliani, and Carlos Sole. And I want to just, as we're welcoming people in, and I know we have a very large crowd, so I'll speak, and then as people are joining the webinar, we'll be able to get into it here in a minute with Francisco, like I said, formally introducing our panel. But I just wanted to note that we convened this because we wanted to quickly have a discussion in reaction to the hydrocarbons law passed by the National Assembly at the end of January. But I would also note, and I'm sure everyone saw the images rocketing around social media the last 48 hours of the Energy Secretary Chris Wright's visit to Venezuela. He's there as we convene today. There's some very interesting, meetings and handshakes and in quotes that we've all been seeing. And earlier this week in a podcast, he told, in sort of prefacing or advancing the idea behind the trip, which hadn't been formally announced, but he advanced that he was going to connect directly face to face with the interim leadership and the oil and gas industry and travel to oil fields and see operations on the ground. And so I think this is, as we saw from a lot of the images, from the statements he made at the Miraflores Palace, an amazing, amazing moment in time. And so I think what we're going to talk about today will really add some real contour and context to the statements and this visit, right? And why he's there and just everything that's happened in the last several weeks. So with that, I want to again thank our panelists. Thank you all for dedicating your time, sharing your knowledge and expertise with us. The Baker Institute, everyone there, Serena and Melissa, Francisco, of course, all of you for joining us, the team at the Institute of the Americas. Thank you. See you here in La Jolla. But now I'll hand it over to Francisco to get us going with the introductions and really get going on the webinar. Francisco.
Thank you very much, Jeremy. As Jeremy mentioned, my name is Francisco Minaldi. I am the director of the Latin American Energy Program here at the Center for Energy Studies at the Baker Institute at Rice University. On behalf of the Institute, it's my pleasure and honor to host this webinar in collaboration with the Institute of the Americas, which have been a great partner over the years, and also Jeremy. We have been working for a long time as Jeremy mentioned, they organize the premier Latin American Energy Conference every year in wonderful La Jolla. And I highly recommend you. He just mentioned the dates in October, but you can go to their webpage and check it out. It's really, really highly recommended. And this year would be, of course, a very particularly interesting year. And we have done a variety of other events together. So we are pleased to do in this sequence on Venezuela this year and hope to do other in the future. So, of course, the topic is very timely and relevant. Venezuela has some of the largest oil resources in the world, but just produces less than 1% of the world, of the global oil. But that might be about to change. The removal of Nicolás Maduro and this new political reality of cooperation between the US and Venezuela offer, of course, a unique opportunity for attracting foreign investment to the crumbling oil sector of Venezuela. More than $100 billion will be needed to bring production back to historical levels. But the national company PDVSA is in ruins, it's in default, one with very limited capacities. So it cannot lead the recovery. It would have to be private investment, and most of it foreign investment. After decades of resource nationalism and contract reneging, more recently, coupled with the US sanctions, this new juncture promises a new opportunity. The new hydrocarbons law, of course, is a keystone element in that potential recovery. And it significantly dismantles the state-dominant model that Hugo Chavez created more than 2 decades ago. It, at the same time, gives some legal footing to an oil opening that was de facto happening in Venezuela in the last few years, in a way that was opaque and didn't have sort of the legal grounding that this offers. And it also creates the possibility of a flexible royalty and tax regime that could offer a competitive government take, which was one of the issues, of the many issues that made it really hard to attract investment. It also offers investor protection mechanism. However, there are still some lingering questions of legitimacy, of credibility. The law gives tremendous discretion to the oil ministry. The implementation of the law, the contract design, and the procedures for allocating these contracts will be crucial for the success of the framework. Similarly, political developments, we are not here to discuss the politics. We are going to be discussing the law and the framework. But political developments in Venezuela and the US, of course, could have significant impact on the perception and the reality of that stability. And so with that, we have an amazing panel, as Jeremy mentioned. Today, we have our featured speaker, Elizabeth El Juri, who will be introducing to us the law. She will have about 15 minutes for that. And then we will have a great panel with Fulvio Italiani, Jose Vicente Zapata, and Carlos Solé, each with an initial contribution of 5 minutes. And then we will open for discussion. Please write your questions in the Q&A section, and Jeremy and I, which will be moderating, will try to incorporate as many of your questions as we can. So very quickly, I wanna you can of course check in the web and in our invitation the CVs of these great speakers, but just some brief introductions. Elizabeth is an international energy lawyer and executive focused on oil gas in the Americas. She was the co-founder of 2 private equity-backed upstream companies over the past decade, the very successful venture in Mexico. She serves as an independent arbitrator and major international oil and gas disputes, and has very significant experience in political risk management. Until 2015, she was in legal practice in the region, initially based in Venezuela, and was head of Latin America for Norton Rose Fulbright. And she was the past president worldwide of the Association of International Energy Negotiators. So we couldn't have a better featured speaker. Fulvio Italiani is an attorney with Ampere, specializing in corporate mergers and acquisitions, in energy and finance law. He has participated in most of the significant acquisitions, financing, and oil and gas transactions in the that have taken place in Venezuela in the recent past. Before joining Ampere, he was in Scale and ARPS. And like Elizabeth and myself, he's a graduate from Universidad Católica Andrés Bello. I'm an economist, but they are both lawyers, and we all met there a long time ago. So I'm pleased to have 3 alumni of Universidad Católica together here. Jose Vicente Zapata is an attorney and partner of Holland and Knight, Bogota's office, with more than 30 years of experience in the natural resources sector. He focuses on the practice of corporate, contractual, and commercial matters with a strong focus on mergers and acquisition, and he co-chairs the firm's Venezuela team, a group of partners that will assist clients with interest in the country. And last but not least, Carlos Solé, a great partner here with us at the Baker Institute. We do our annual Energy Summit with Baker Botts, and Carlos has been a great partner there. He's a partner of Baker Botts and chairs the Global Projects Department and the firm's Latin America practice. He concentrates on domestic, international, corporate, and finance transactions with a particular focus on the energy industry. So with that, Elizabeth, please present your introduction, and then we will move on to the panelists. Thank you very much.
Thank you, Francisco and Jeremy, and of course the two institutes for the invitation. I'm going to jump right to it because of timing, of course. So what we're going to do today is tell you about this very fundamental change with the new hydrocarbons law that was passed a couple of weeks ago. It is without a doubt the most significant adjustment to the oil and gas framework in 20 years. And as you know, the question on Venezuela has never been about reserves. It's more about what we call in the industry the above the ground risks, right? That the regulatory and the fiscal regime, the contractual structure, and the institutional governance. In my little introduction, I'm first going to tell you what I am going to cover and what I'm not going to cover so that you have the full picture. And then we'll go into details as time permits. So first of all, I view the reform as almost a transitional change, but that was a huge effort to stabilize and grow the production in the near future, to validate the existing contractual structures that have been put in place, in particular since 2020, under a separate legal regime that was extraordinary or outside the former hydrocarbons law. But it also introduces operational and technical flexibility, and of course, fiscal flexibility to the extent it's implemented. I'll explain all that under continued state control. So overall, the law has some very significant and meaningful improvements. And I want to give you the highlights first. So we have a general theme of, from an investor perspective, if you're going into the oil and gas business in Venezuela, there are a number of improvements, such as, for example, for the first time in a law, it had been found in administrative contracts, you find a mandatory provision mandating the inclusion of a clause for economic equilibrium. Now, anybody who works on concessions or toll roads, et cetera, highways, you're familiar with the concept. But essentially, it's a concept that is, for our industry, typically known more as a stability provision. But it essentially seeks to, for the life of the contract, give you or maintain that economic equilibrium. And that clause is mandatory, or that provision that I'm referring to has a mandatory nature. On the other hand, there's a few that are not mandatory, but yet significant improvements if they happen to be implemented in the contracts. The contracts are yet to be seen, right? The law is only 2 weeks old. And but assuming they're implemented, these are positive. So first I'll mention, it's close to my heart, and it's a very significant, one of the top 3 criteria that an investor looks at when you're investing in a new country entry is, do you have access to international arbitration, to a neutral forum outside the host state? And the answer is the law does not mandate arbitration, and it doesn't use the word international, but it does permit arbitration. And I'll explain a little more later on. It also, on a positive note, creates a new form of investment in the business. Now, at a very high level, granting instruments in oil and gas hydrocarbon or in hydrocarbon jurisdictions are in one of 3 buckets. And one of them is licenses and concession, which is not what is being granted here, but it is what we have, for example, in the Venezuelan gas law. You have licenses granted, so direct E&P rights granted to a private participant. That's not what we have here. But we also have other forms of investment in this industry, and one of them is typically known as a production sharing contracts and profit sharing contracts, depending on how the remuneration is structured. And even though the chapter on contracts that we're going to see in the law, and we're going to talk about a little bit, doesn't put a label or a title to them, when you look at the features, it's very much akin to a PSC, and that is a positive new alternative form of investment, in addition to the mixed companies or incorporated joint ventures that have existed for the past 20 years. It also, on a positive note, has created the opportunity for a more flexible fiscal regime. That has a positive and a negative, because it is not entirely clear and it's discretionary, and I'll get to that. But on a positive note, it has replaced numerous taxes, levies at every level, including state and municipal, numerous prior fiscal contributions that were in our fiscal system a laundry list of taxes have all been replaced. Essentially today, we're talking about three concepts. Talking about two gross volume and gross driven taxes, which are the royalty and the integrated tax, and one applied on net, which is a hydrocarbon income tax, and I'll get into that as well. And the final highlight I want to give is, even though it's not mandated and it has to be approved by the ministry, marketing rights on the natural hydrocarbons are now allowed for either the private shareholder in the mixed company or for the contractor in the what I've been calling the PSC contracts. So the law clearly preserves and perhaps reinforces the executive powers role as well as the discretion. So it doesn't really constitute, in my mind, a fully competitive, self-executing, a hydrocarbon regime that would be comparable to some of the Latin American hydrocarbon jurisdictions that surround us. And we all know that money flows on a global competitive basis. So we are going to be compared as Venezuela based on the terms that we offered with other jurisdictions that are also hydrocarbon producing. Now, we also, just as a caveat, before I turn to the details, I also want to mention that it is important to bear in mind that the law is a piece of the puzzle. And what I mean by that is that you can have a perfect law or an imperfect law. At the end of the day, it doesn't matter too much to me, because you also have to see outside the law, you have to see concepts like the rule of law, other laws and part of the regulatory framework beyond the hydrocarbon law. You have to see the regulations to the hydrocarbon law that are yet to be passed. The current ones are 80 years old, 83 years old. And you also have to see, in addition to the regulations, you have to see the contracts. And that will be kind of the proof is in the pudding, or the devil is in the details, depending on which one you like, in terms of how this will actually be implemented. So what I'm asking you today is to understand that our comments, or at least mine, will be based on what is in the law. And that is one piece, but it's not all of it. And at the end of the day, of course, from my perspective, to see high capex, long-term international oil company investments, you need the full picture. You need more. I think yesterday's comments from Secretary Wright were directly on that topic, so I'm not going to get into that. But I will say that it is a huge improvement as an instrument, and it is much better than the one 20 years ago. On a personal preference, I would have liked to see a full amendment of the law, a comprehensive amendment of the whole regime. And the oil and gas industry does not like incorporated joint ventures. So preserving the mixed companies is an option, and the attractiveness is a huge question mark for me. But at least there is now a new alternative, which are the contracts. So one of the topics I mentioned was the discretion of the executive power. I just want to list for you very briefly where this comes up, because it's a recurring theme in the entire law. You have either a decision of the ministry to be made or an authorization to be granted by the ministry. When I refer to the ministry, I mean the Ministry of Hydrocarbons, on the following topics: the right to market your natural hydrocarbons, the right to open and maintain bank accounts in foreign currency, the establishment of the entire government take. It's interesting, but the law no longer says the royalty is 30%. It says it's up to 30%. And it doesn't say the integrated tax is 15% on gross. It's up to 15%. So all those details will be set by the ministry, and then the hydrocarbon income tax rate by the Ministry of Finance. And of course, that also exposes you to reinstatement. And the question is, how are the contracts and how is the legal framework going to address issues like you get a royalty cut, but when can it be reinstated? What happens if it's reinstated? And last but not least, the law requires the ministry to want to give you arbitration. Now, on arbitration specifically, there's going to be more guidance, because there is a specific mandate to the ministry with the Attorney General's office together to develop general guidelines that will tell us more. It will tell us, what's the seat? Can it be a foreign seat? Will there be waivers of sovereign immunity? Can we have institutional arbitration or only ad hoc, like UNCITRAL? The contracts that have been granted in 2020 had UNCITRAL international arbitration, but not institutional. It was ad hoc. And those contracts, by the way, are not publicly available, but that has been confirmed. And so on the topic of arbitration, when we see the guidelines, we'll see how far you can go. And to the extent the contract is consistent with the guidelines, you need no further approvals. The concept of economic equilibrium, I think what will add to what I said earlier is simply that it seeks to protect you, and that's why I call it a stability type provision. Under any material adverse effects on the economics of your project that arise from what? From legal, fiscal, and regulatory changes. So, or any contract changes. So that it tells you specifically if any of those changes occur and they alter the economics of the project, there shall be an obligation to make the adjustments, to restore the economic equilibrium to where you were, but for those amendments, but for those changes. And it contains a number of examples of how that will happen. They may reduce the royalty rate. They may extend the duration of your E&P contract. So maybe you had a 25-year contract, you get an extra 5 years because they need to restore that balance. In terms of private participation, as I hinted, in addition to the mixed companies, there is now a third instrument. Only mentioning the changes on the mixed companies very quickly. They are now excluded from the public procurement laws. So procurement will be easier, much more friendly for private investment. And more importantly, the entire operational and technical management of these projects, call it the operations of the mixed company, can be delegated to the private investor. And now that has a legal basis because this has happened before, but now we have a solid legal basis for it. And they can do it directly or they can do it through what we would call oilfield services contractors. There's a proviso there. They can do it privately as long as the cost per barrel will be lower than PDVSA's cost per barrel. So the cost of production per barrel has to be lower than PDVSA's. Otherwise, it will not go to the private sector to manage or operate those mixed companies. In terms of the new contracts, in addition to having a reference to verifying the suitability and capacity of the contractor, there's absolutely there's no regulator of the oil and gas industry that is created in the law. So there isn't a separation like there is, and you highly recommend when you go into these countries, designing these frameworks, you'd like to see a regulator who's independent from the national oil company, is independent from the ministry who collects the royalty. There is no regulator. It's all going to be a contract with the national oil company. So it's like PDVSA signs a contract. How it gets selected, who gets selected is a question mark. There's no maximum duration for the contracts, which is interesting because there's a maximum duration for the mixed companies. And the key is the remuneration can be a share of the production or a share of the profits. So that's why I call them production sharing contracts or production sharing agreements, depending on what they are. And to finish on two final topics on the fiscal regime, I've already mentioned that the rates have to be set. I think what's important, because we don't have time to go into all of it, is that you realize that there is, in the worst case scenario, and you have to, when you make these investments, plan, first of all, for the worst case scenario. And then if you get a break, you have to be sure that it can be enforced for the life of the project, because otherwise you have to run the economics based on the higher tax. So you have worst case scenario, a 30% royalty, a 15% integrated tax. So that's 45% on gross. One is on gross volumes, the other one is on the realization value of the gross volume, so gross income, let's say. But that's 45%. Then the income tax rate for the oil and gas business is 50% if it's not reduced. Some rough calculations tell you that that's about somewhere in the range of 5 to 15% gross, equating 50% of net. You already say roughly 60% of gross value in equal terms that goes to the base. But what happens if you have a production sharing contract? You're also going to be sharing that production with PDVSA. So if the split, for example, is 60-40, 40% of the value of those barrels are also going to the state. So when you look at government take, you're going to look at the whole package. And last on the topic of marketing two last topics, sorry. On the topic of marketing, the marketing rights have to be authorized by the ministry. But again, there's a proviso. The realization prices have to be better than those obtained by PDVSA in the markets. So they don't want to see you dumping or making arrangements where they bring the oil prices down. And they have to comply with the domestic market rules that the ministry sets. that is pretty scary, because one of the other critical factors that you look as an investor is, do I have the right to monetize? Do I have the right to export? So the complying with the domestic market as a question mark is a little bit of a concern that should be clarified again in regulations or the contract. I will leave it there because of time. Thank you, Francisco.
Oh, thank you, Elizabeth. This has been an amazing summary, an overview of the law. I think I have read a few of these, and was outstanding. So, Fulvio, I think you're going to share some slides. Yeah. So please do so. Go ahead.
Yes, thank you. Thank you very much for this invitation, and thank you, Elizabeth, for this very comprehensive overview of the amended law. I will focus only on one aspect of which I believe is central to investors, which is the government take. So I prepared these slides to go over very, very fast. So you have first the royalties. As Elizabeth said, before you have a fragmented system with lots of specific taxes, royalties, additional royalties, windfall tax, extraction tax, parafiscal taxes. In addition to being fragmented, it was hidden, and there were ambiguities about how to calculate them. The windfall tax, it was not clear how the government would calculate that, because the basis used to calculate the windfall tax was a secret. So it was very non-transparent what was the fiscal take on royalties. Then you didn't have a cap as we have now. You had a floor of at least 50% on gross production, what was called the shadow tax. So you had a rigid take that did not take into account the project economics. So it was regardless of what you had to invest, the tax was the same. So you have high execution risk. Now you have an integrated structure. It's basically a 45% cap on a royalty on gross revenues. Call it royalty or integrated oil tax. It's just a cap of 45% royalty set by the ministry, project by project, based on capex, economics, and competitiveness. This is what the law says. It's not those are the bases they have to use. The rates can be calibrated. Now, not only can you lower, but you can also calibrate them throughout the time of the project. Lower in the early stages, higher once the cash flow stabilizes. So it gives a lot of flexibility for particular projects that maybe need some help at the beginning, and then you can tax them higher at the end. No statutory minimum floor, so we expect the shadow tax to be eliminated also for the existing JVs. We'll see. The express economic equilibrium protection, as Elizabeth mentioned, which is a great inclusion. And very interesting, there are some legacy contracts that the government has announced that they had at least 29 contracts that the government already signed, and the law says that they retain their agreed take. So once we know the participations that the government is giving in these CPPs, we will know how they have applied this system. This system has already been applied. We will know how flexible they have been on this cap. Once we know the terms of those contracts, it's 38, it's 20, it's 18, it's 50. We'll see. Hopefully we will learn that when this becomes public. Then we go to the income tax. Reality, the income tax stays at 50% of net profits. The difference here is flexibility for the Minister of Finance and the Minister of Hydrocarbons to reduce the rate at the project level if this based on capex, economics, and competitiveness. And this is important, so you don't need to go to a law, a statutory amendment in order to lower the tax. The government can lower the tax for specific projects, and this is designed to preserve economic equilibrium. Then an important portion of the governmental take, the government take, is structure. In the contractual model, since you have 100% private participation, zero state equity, you're going to have a fee for use of area and lease of assets. I understand in the legacy CPPs, the percentage was very, very small percentage, 1%, 2%, 3%. So that should not be material. But the good thing about the contractual model is that there will be no state participation in post-royalty, post-tax, and post-fee distributions. So the private party will retain full residual cash flow after royalty, tax, and fee. On the contrary, in the JV model, in addition to the whole taxes, royalties, you need to take into account the equity stake of the government, because that's also government take. So the state will capture the equivalent share of the post-royalty, post-tax cash flows. The only alleviation here, there are three kinds of alleviations that you could have here. One, if they apply the Chevron model to some JVs, that will allow like the investors to sort of like be paid with the legacy debt before dividends. So that would be a cash flow improvement. This is what you have in the Chevron model. Then the potential alternative will be like that the state reduces its stake on the existing JVs from 60 to 50.1, either by transfer for consideration or by dilution as a result of like new capital infusions by the private partner. So you can reduce 60% to 50.1%. And an idea that we could be interesting is whether an existing JV could like convert into a contractual model. Is that feasible? The law does not prohibit it. It could be an option, because clearly, at least under an economic standpoint, and taking out the big issue of booking of reserves, the contractual model seems clearly more advantageous for an investor, given that you don't have the equity stake. Then reserve bonus. This concept existed before, but now is recognized in the law. The government may apply to the new JVs and to the new contractual model. They did not apply to legacy CPPs. CPPs were not required to pay reserve bonus. I think that the government expectation is that whatever they set as a reserve bonus, which is generally is like a dollar number on proven reserves. That's how they calculate it. So they may expect a cash payment, but hopefully, this is a big policy issue. They'll have to consider whether they accept as payment offsets against legacy commercial or financial debt, Republic of PDVSA bonds, and arbitration awards. That would be an incentive for the economicity of the projects. Then, as a big conclusion here, the three conclusions that I have from this law is like, we are moving from a fixed to a discretionary model within statutory caps. The discretion will allow calibration to project economics. So this could be an incentive for capital intensive or longer payback projects. And whether this framework will attract capital will depend on model contract design and fair and consistent application. Thank you.
Thank you, Fulvio. This has been a great review of all the issues related to the fiscal regime. I really appreciate it. So let's go to Jose Vicente Zapata for his comments.
Thank you, everybody, and again, a pleasure. And it's always a pleasure to be with these colleagues here in this conference. So I think Elizabeth mentioned something that I think covers what I'd like to refer to in 7 particular points in the minutes I have. The first issue, and the word you use, which I totally agree with Elizabeth, is transitional regime. It is a regime that is being structured for a transition. Now, the problem with that ties into that is essentially the issue that was also mentioned, which is the state participation throughout this transitional regime. And what we have in other parts of Latin America, of course, is independence and objectivity in the regimes. And when you see what's been drafted, the concern, of course, is that state permanent participation, whether it be that ministry further regulation, the approval, the okay, the green light to move ahead, those types of conditions, of course, make it a transitional regime that is still far from the international standards, as I will further mention. So when you look at that, 7 key aspects that I'd like to highlight. The first is the stability of the change. And there are clauses there. Reference was made also to the economic equilibrium. I'll expand on that in a minute. But the stability of the regime is a key concern for, of course, foreign investors and foreign companies participating in the local market. We all know, and Francisco mentioned it, the potential is there. But the key issue really is how stable is the regime? And from what we've been reviewing, the concern is, of course, if this rule of law is able to change periodically and does not have the institutional capacity to maintain stability, then we're looking at a regulation like we always look at in fiscal regimes throughout Latin America, where every year there's a tax reform. So when you get the question as to, how do I operate in long-term contracts? Because the intent here, when you look at the mixed company regime, which is 25 years, and then you can extend it for a certain period of time, and you're looking at all that, you say, okay, well, this is a long-term bet, now with a changing government with respect to its position looking at the oil and gas sector, how do you stabilize that so that an investor has the key aspects that you need to be able to invest? And then that ties into something that I would say Fulvio is also mentioning, which is basically when you look at that, it's not only the oil and gas regime, because of course that's part of the picture. We also have to see what's happening at the global fiscal regime system, what's happening at the governance system, what's happening with security measures and security in country, what's happening with the labor law, all those other regimes that have to be able to also find a stable environment to invest and undertake operations. The second aspect that I'd like to mention is the changes that are being introduced vis-a-vis international standards in oil and gas. And I think that there's a lot of things still missing. And the concern is, of course, because that is missing, then there's going to be a push, like we've seen in other countries, to have those international standards that have been there for a long time kicking into the regime. How does that work? Or is it that the regulator will further regulate such that starts to be reflected in the contracts that are going to be moving into the future, into the picture? And that ties into the competitive environment of the discussion, the applicable laws of the discussion, and of course, the operational technical reality of the discussion. One of the things that we always like to highlight is everybody's talking about the change, everybody's talking about what has happened, what's coming, right? But at the end of the day, the nitty-gritty is what has to be addressed so that things can move faster into reality. The third aspect that I already mentioned is, of course, state control and intervention with the history that Venezuela has had. And the concern there is, of course, the day-to-day of contracts, the day-to-day of the regulation, and now it's going to be applied. Because, of course, when the concerns we have historically is you may have a great regulation, and as Elizabeth also mentioned, you can have whatever the regulation says, but if the regulator or the government modifies that de facto, then of course it doesn't make much sense that you have a regulation that nobody's respecting with respect to the rights of the investor or the operator of record that's in the scenario. That's the third aspect. The fourth is the economic equilibrium discussion, vis-a-vis, again, stability. That notion of contractual equilibrium has been there for a long time in many commercial laws throughout many jurisdictions. And then the question becomes, does it really work both ways, or how does that fit in? Fulvio, you just explained brilliantly all the fiscal aspects of this. But so if there's a lack of equilibrium in the contract, does that mean that it's stabilized, and therefore when these things change, then you can maintain your rights under the preferential economic conditions that you had as of the start, or not? And we think that that is a concern. With respect to arbitration, I still have a hiccup, Elizabeth, Carlos, Fulvio, and Francisco. Can we agree to international arbitration or not? This is a big discussion. Choice of law ties into that. Does it have to be or not the laws of Venezuela? And the reason for that, again, is, and I imagine Carlos will refer to that, I have here printed out the general licenses that have been issued. Our information shows that the general licenses will continue to be issued. We're apparently waiting for 4 more or 3 more. So this is like a day-to-day general license discussion. But in the licenses, the key aspect is any contract for any transaction with the government of Venezuela, PDVSA, entities, or whatever, has to specify that the laws of the United States or any jurisdiction within the United States are the ones that govern the contract, and any dispute resolution under the contract occur, et cetera, et cetera. So that's a big issue. So you're looking at a new regulation and a new regime. And as we all know in Latin America in general, these regimes tend to apply local law because of the sovereignty discussion around the resource we're talking about. So if you're trying to agree to an international arbitration, well, is that going to be tied to a different choice of law, or is it going to remain Venezuela law, local arbitration? And then the discussion is, of course, how will my rights be upheld within a regime that, of course, has a loophole with respect to the manner in which arbitration may eventually be carried out. The sixth aspect that I just want to mention is liability. Unfortunately, there's a lot to be said there. Just for background purposes, we're looking a lot at PDVSA's historical debt, existing unpaid obligations, legacy liabilities, financial restructuring discussions. So there's a lot there that is still unknown, because some investors have been there or were there and now want to come back in. And one of the questions is, of course, what about the past? or is it just now, let's look at the future moving forward under this new regulation? And last but not least, a main concern on compliance. I just referred to the general licenses, but basically the concern is something that we're still missing. In all the discussions we're having in this sector, there's a twofold discussion. The compliance discussion from a corporate law perspective, from a commercial law perspective, with the entities themselves. But then there's a compliance OFAC, listed individual, persons of interest discussion with specific individuals that are in office or out of office, but that hold the rights or are shareholders to those agreements and structures. And what about them? So can I sit down with somebody that has been under investigation, internationally speaking, in my discussions to uphold my contractual rights, renegotiate my contract, or obtain a contract under the new regime, under the new law? So those would be the aspects that I'd like to highlight. Thank you, Francisco.
Thank you, Jose Vicente. And now, Carlos.
Thanks, Francisco. Thank you, Jeremy. Thanks to the Institute, both institutes, for inviting me. Let me try and supplement some of the observations that everyone has had. First, some high-level reactions on the law, and then spotlight and discuss some near-term events that will impact what the investment landscape will look like, and then let me kind of prognosticate as to what sort of the near and medium term might look like in terms of investment, as well as the long term. So touching on the law, I think as Elizabeth mentioned, the key thing is, yes, the law is an improvement, but ultimately there's a significant degree of discretion that remains with the government. And if the government exerts the highest amounts, then those highest royalty rates and other elements will be extremely high. And to supplement Elizabeth's theme of understanding the whole landscape, another important aspect of the landscape will be the personnel to actually administer and implement this. And yes, the international arbitral clauses are important, but we haven't mentioned, we should not forget what happened in 2007, 2008, 2009, the variety of expropriations that occurred, and the judgments that have been levied against Venezuela, and the creditors that are trying to seek and collect those billions of dollars that are owed to them. Sort of shifting then to, so what are some near-term events that will impact what this investment landscape will look like? There have been 3 OFAC licenses that have been granted to try to the extent you can sort of begin the process of normalizing commerce. The first related to oil trading. The second related to the sale and supply of diluents. The one yesterday related to the provision of oil field services. The one we're all waiting on is what's going to happen in terms of, is there going to be a general license that's actually going to allow the undertaking of exploration and production activity in country? And as Jose Vicente just mentioned, the prior 3 licenses have all had the requirement that the contracts have to be governed by U.S. law, which in the context of an oil trading transaction, okay, that there's a customary basis for achieving that. Same thing with oil field services, same thing with diluent supply. Very different dynamic when you're talking about in-country EMP activity and how will the sovereign react to that. So we'll have to wait and see. The other 2 key dynamics, I think, here in the near term, there has been a court-administered sales process ongoing for, I think it's almost 2 years now, where there is a preferred group, Amber Energy, that's backed by Elliott Advisors that would be willing to buy Citgo for, I think, $5.9 billion is their amount. That has just sort of been there on pause, and so we have to see what happens with that. That happens to be something that's probably one of the few things that's able to unite both the current presidency in Venezuela as well as the opposition. Both of them are opposed to that sales process. So we'll see where that dynamic plays itself out. And then lastly, the other issue to wait and see is the U.S. government going to create some types of claims commission where creditors can pursue their claims and get their monies. Right now, everything that has been structured in a manner where proceeds from oil sales are off limits to creditors. So we have to see how that evolves. So what does this whole backdrop and panorama mean for near and medium term activity as well as long-term investment activity? Look, I think for the near and medium term, for participants who remained in country, like Chevron, Repsol, others, their risk profile has been improved. They've got an opportunity now to build upon their existing infrastructure and assets, perhaps not to the long-term degree they might if you get a greater degree of legal stability, greater respect for rule of law, but certainly for what they have to make some investments to improve on the margins. For E&P participants, it's a high-risk environment. So, the wildcatters or those who have a high-risk appetite, I think will be willing to jump in. And then I think, for the long-term investors, maybe Francisco, I saw your quote in the journal yesterday, which I think you said something like you'd have to be out of your mind if you want to come in and invest in the Orinoco Belt. So I think for the long term, there's a lot still to happen before we see the billions of dollars that will really turn Venezuela around.
Thank you very much, Carlos. Great comments. So I leave it to Jeremy to start the questions and discussion.
No, I thank you all. I add my congratulations. Amazingly, insightful in limited amount of time. So kudos. So there is an enormous amount of comments and questions coming in from the audience. Thank you all very much. Let me try and summarize. We called this subtitle of this webinar Scope, Intent, and Viability. And I want to focus on the last word there, viability, because I think that's where, if I summarize a lot of the comments and questions coming in, it's around the viability of the law. Confidence, the word confidence is something we're hearing a lot, and you see that in the questions. And so the question, and what I want to pose to the panel, maybe we can go in reverse order really quickly, is with regards to what this law does. What's the objective of this law? Is it to provide confidence? Is it to simply do a near-term boost in some of the production capacity? Is it much more geopolitical? Is it just simply responding to the new pressure from the United States? And so the question is, where does the new law place Venezuela in this global competition for capital? And Elizabeth, you highlighted that, you called that out very clearly, right? And so it's a series of points that can be summarized here into the legality, the certainty, the confidence of this new law, and does it offer Venezuela a place in the international arena and competition for major capital in a sufficient capacity or a sufficient level? And so let me just, and I know that's a lot packed into one summary comment and question, but Carlos, just quickly react to that and that word viability and confidence.
Look, I think it depends on the investor risk profile. If you wrote out the expropriations and remained in country, you've been marginally de-risked for marginal incremental investments. If you're a wildcat or an E&P player that's willing to operate in a high risk, high reward market, that's a marginal amount of capital, a significant amount of capital, but not a tremendously significant one, then there will be those participants that enter. If you're looking at a long-term billions and billions of dollar play, then I would say that the environment is not there yet, and just time will tell.
Thanks. Jose Vicente, does this offer certainty? Does the interim government passing a law like this provide confidence?
I'm going to say something practical in nature. And I think part of the reality from a legal perspective that we're facing in many jurisdictions, I'm in Bogota, and same thing here, same thing in Peru, same thing in everywhere, is this is you have to be able to pass this reality and learn how to work in these environments. And so if you want a perfect world, then it's probably not right now. You got to wait like 100 years. But the reality is as is. What we have to learn, and that's why we're here to assist from a legal perspective always, is what do we have to include in the contracts? What do we have to look at from a regulatory perspective? What do we have to look at the compliance aspect? How do we structure this so that we move ahead? You can't just simply be waiting and waiting and waiting and waiting. And I think that wait, if not moving forward, is very expensive for investors in this sector, and you lose the opportunity. And we see this everywhere with different realities, and this may be a very complex reality, but with different realities, but we move forward. So I think that the name of the game is being able to address the concerns and move forward.
Thank you. Fulvio.
I would say that this is a step. It's not the first step, but it's a very important step in the right direction. Whether they manage to apply this consistently, fairly, and demonstrate that this is workable, this is forward. But the reality is that this law is not creating something out of nothing. This is validating something that this government has been trying to make, has created 3 or 4 years ago. In that law, if you look at the law, they are just validating the Contrato de Participación Productiva, the CPPs, which is sort of like a model, this kind of contracts that Elizabeth mentioned. And they are also validating what was called the Chevron model. This is there. Right. They're basically validating what has already been there. Whether they are gonna go the next mile, having contracts at the international levels with international arbitration, which, by the way, they have already accepted international arbitration in these CPPs. Not all of them, but some of them, they have international arbitration, accepting parties as an outside, a city. There is no restriction for having arbitration in the US, no restriction whatsoever. It's a matter of whether they would be willing to do it. So we'll have to see if the next step goes in the same right direction.
No, that's a great point. I like the word you used. This is an attempt to validate those existing frameworks. So okay, Elizabeth, we started with you on this question. Let's end with you, particularly around what kind of certainty does the interim National Assembly or the interim government's National Assembly provide?
Sorry. Let me address the question properly, maybe at a high level first. It's when you say and make comments like, oh, people are going to go and invest or they're not going to invest. Again, this is a comparative exercise. Yeah. And it's not only about the above the ground risks that we're talking about right now, which have to do with stability, long-term laws, et cetera. There's a big piece of it that it's about the numbers, the economics. And what happens here is that there's I would say almost two tests that have to be met, or thresholds. One is the fiscal regime has to be at least comparable and within the average of the global one. So in my mind, that's kind of roughly under 70%. And the issue we're having with Venezuela is that the fiscal regime is not in the regulatory regime. It's not in the law. It says it can be from here to here. So when you run those numbers, ballpark, you could end up with a 45%, or you can end up at 94%. And so that level of uncertainty and not understanding whether what is being offered to you will be maintained over the 25 years or 30 years of an upstream project is a big deal. So one aspect is the fiscal regime attractive enough? Is the government take within a reasonable a margin of what the competitive projects would be in other jurisdictions? That's one aspect. The other aspect then turns to these other risks that you're pointing to. And let's say that the law is used in these and implemented through these contracts, the regulations and other laws are passed that all taken as a whole start to create a solid framework. Yeah, I disagree that you have to wait 100 years. I think that as an investor, you take some risks. Investors are used to taking risk. Investors in the oil business are used to take significant risk, because I always say that there's an economic principle, right? I would say it's direct proportionality. In this case, the higher the hydrocarbons, success, the higher the government take, the higher the risks. Switzerland is very safe, but there's no oil. So I think we need to understand that there is a level of risk that these investors are used to taking, but the thing is they're going to be comparing it to other places, and in that comparison, Venezuela may or may not win. Now, assuming that there's a decision, I want to go to Venezuela for whatever reason that decision is made, the attractiveness, the geopolitical, the location, getting comfortable that those terms will subsist the passage of time and survive, is something that I don't think today people putting in billions of dollars can call that. But I do agree with my co-panelists that more opportunistic investments, smaller investment, especially investment in developed fields where they're already there and the infrastructure is there and you just need to revamp the production, that's almost a no-brainer. The issue is, and that will increase production. There's a consensus in the industry that there's going to be a few 100,000 barrels that are going to come out pretty quickly a day that are going to be added easily. The problem is to go from where we are today to our historic peak production or anywhere closer, is a different level of investment, not only in numbers, but in comfort, in terms of who can do that, who has the technology and the capital to make those investments in the billions.
Absolutely. And just, Francisco, I want to turn it back to you, but I'll read from what the Secretary of Energy said directly yesterday. And he said, responding about the new hydrocarbons law, it's a meaningful step in the right direction, probably in my view, not far and clear enough to encourage the large capital flows you'd like to see. Echoing your just final statement there, Elizabeth. So Francisco, throwing it over to you for the remaining minutes, but let me ask you a question. It seems like perhaps the strategic objective of this is to boost some of that few $100,000 barrel capacity, to boost production here in the near to medium term. And then as we move along a more incremental pathway, perhaps additional regulatory, legal reforms, fiscal reforms that would speak to these big ticket, large scale kinds of investments that I think we're all ultimately looking for, right?
Yes, I don't want to take much time, but one of the concerns I have, which I think you're right, and everybody has mentioned it. There are some short cycle brownfield investments that can be done with a short-term horizon, and those can be covered by the current situation. However, there are a lot of uncertainties in the following sense. First, some of the best assets in the country are assigned to Russian and Chinese companies. And so what's going to happen on that part? Second, the 29 CPPs that have been already granted cover a lot of the production of the fields that PDVSA used to produce themselves. So what is there for the future in terms of the sort of the longer term investment if you already have signed so many of these areas, to not necessarily the actors that are capable of doing this type of investment. So for the last round, I think we have only like a few minutes left. We can pass a little bit of the time, but I would like short answers. But I wonder if you could, if each of you, going from Carlos to, again, Elizabeth, could talk a little bit about the two types of options here, right? The mixed enterprise, you have a majority shareholder who's still this company, PDVSA, with all the problems that it has. This seems to fit with the constitution that says that the sector has to be, controlled by the government in some way. But it does offer challenges. Like, for example, would you have to carry the capital, the capex of PDVSA, for example, adding some significant additional risk? And that's the history of Venezuela recently. Can you talk about the booking of reserves in both options too? And in terms of fiscal framework, the fact that, as everyone has mentioned, you have to have a balance between profitability and government take. That will be at the level of the contracts. But here, the issue, of course, is how are these contracts going to be allocated in a competitive, transparent manner or not? And do you have a formula, like an R factor or rate of return contract, or is this going to be an ad hoc, like every single contract has a different profile of royalties and taxes? So to speak about the difference between these two types of contracts, I know that we don't know all the details, but if you can just briefly talk about any reflections on these issues, and then we will close, starting with Carlos.
Yeah, so I think for the reasons you identify, I think future investment certainly the advice I would give clients is if you can stay away from the empresa mixta structure where you have to have PDVSA as your partner, you're better off doing this. I think it's a CPP new framework where you can do it on your own for all the reasons you described from the CapEx perspective, as well as having to engage them into your decision-making process. And yeah, you raised a question that I would defer to Fulvio and Elizabeth on as to whether, the impression I've had is that these contracts are going to be negotiated on an ad hoc basis. And so then obviously what that potentially creates an incentive for is the potential exists for the initial movers. Maybe the initial movers will get better deals than movers coming later, because if you're coming in early, you're taking on more risk. So then therefore your profile justifies it. But I'd be curious what my Venezuelan colleagues think of those items, but I guess I'll turn it over to Jose Vicente.
I would simply add, I would simply add, I'm always concerned with the two-tier problem that is individuals and companies. And when you look at that reality from a compliance perspective, and from a corporate perspective, where the investors are looking to sit down and negotiate, to your points, how do you avoid commingling of resources? How do you manage the joint operating account when your partners have these issues that are lurking there? All of that has to be addressed somehow. And I don't know if it's going to be additional individual licenses or more general licenses one by one, but there's a lot to be said there, particularly for U.S. companies doing business in Venezuela.
Thank you. Fulvio, take your mic.
For new investors, based on what we know now, like the contractual model seems the preferred option. We'll have to see how that contract looks. I think that's the next big important step they have to take and show the market that they really want to do something that is international standard. So that contract is the most important thing that needs to happen now. I think, the JV is more for the legacy. There are important players here that already have JVs here. And the issue that they have this legacy debt and this Chevron model is workable for them. So I think they kept that for sort of legacy issues. And we have to see if the government is willing to go like the extra mile and convert those JVs into contractual model, assuming that we have a great contract, which we all hope we will get.
Thank you. Elizabeth.
Yeah, I would, to mention a few additional points, perhaps. First of all, no oil company wants to be in an incorporated joint venture. There's issues. You want to preserve your independent tax treatment. You want to do your own depreciation. You want to book your own reserves without being restricted about what the policies of your partners are. So to begin with, nobody wants that. Now, in the case of Venezuela, it's not a regular incorporated joint venture. It's an incorporated joint venture with a state company. So I'm talking about the mixed companies here, to be clear, where the state company has more than 50%, and at least on paper, because the law requires it, it exercises control. So that's even less attractive than a regular incorporated joint venture. It's one level down. Now, from my perspective, so no doubt, there's also issues that arise from the incorporation, for example, trapped cash. When do you have a dividend? Who controls the flow of the funds? Who controls the finances? Even if you have this authorization to delegate to the minority partner. So that seems to suggest, well, the contract is the right path. We haven't seen the contracts, and I'm maybe a little bit more of an optimist, and I will hope that they won't just grab the CPPs, which are an invented creature, and actually come up with a better model that is something that the industry is used to. So nobody's seen them. I will not call them CPPs. I will call them the contracts or production sharing contracts or profit sharing, depending on what they end up being. And I think the only drawback on the contracts is that, in essence, and this anybody who's in this industry knows, a PSC is a service contract. It's a sophisticated risk service contract, but it's a service contract where you're under contract with the national oil company. So you're a contractor. So in an ideal world, you wanted to have the direct E&P rights, but that you get in a license or concession. If the cost of getting that is through a mixed company, I still think I end up voting for the contracts.
Right, thank you very much. Jeremy, the last word to you.
No, there's so much more, and it's the perfect way to allow me to remind everyone that this is the first in a series. And I think, this hydrocarbons law is something we wanted to really dive right into immediately. So that's obvious. I think there will be a lot of what we've already brought up. Hopefully, once we see contracts, once we understand sort of exactly what some of the terms are, we can have another part of our webinar series. There was an excellent comment about the electric sector. Yes, indeed. I mean, we've been focused exclusively on the hydrocarbons law. We all agree that the importance and the similar underinvestment and degradation of the electric sector is something to be considered and understood. I commend to folks essay out today in America's Quarterly by Francisco Morandi, not Monaldi, Morandi, former Electricidad de Caracas and AES, along with Luisa Palacios, talking about the electric sector. I think it's something we'll also come back to in our collaboration between Baker Institute and the Institute of the Americas. As a famous moderator of Meet the Press used to say, to be continued.
Thank you very much. Bye-bye, everybody.
Thank you all so much.